Okay, good morning, everybody, and welcome to the Ridge and Downs webinar about the missing carrots. We're going to talk today about what it means to have a compensable accident under the Illinois Workers' Compensation Act. So I'll start with some introductions for those of you that don't know us. My name is Amy Lee Hogan-Simonovich. I'm one of the attorneys here, as well as Karen Connolly and Brian Driscoll, both attorneys here at Ridge and Downs. Ridge and Downs is an injury law firm. We do personal injury, workers' compensation, and FELA, otherwise known as railroad injuries. We've been representing injured people throughout the state of Illinois for over 4 years. So with that being said, I'm going to start a screen share and do a little brief PowerPoint for everyone. You will notice that in the webinar format on Zoom, your microphones and your video are off. You are able to write questions, and we encourage you to in the Q&A box, as well as in the regular chat box. Okay, so if anyone has a question at any time, please don't hesitate to speak up and let us know. We would love for this to be an interactive process. Okay, so I'm going to go ahead and do a screen share. Oh, and it's going to make it load real quick. Sorry about that. Okay, so as we just introduced Ridge and Downs, and so now we're going to start the case of the missing carrots. Brian, you want to start us off?
Sure. We're going to be discussing the case of the missing carrots. We're going to follow one case through the Industrial Commission to outline what actually constitutes an accident under the workers' compensation statute for the state of Illinois. It is a statutory construct, but the interpretation of that construct has been litigated many times. So, what is an accident? An accident is a necessary component of this statute. So, what are the requirements? To prove an accidental injury is the first step to receiving benefits under the Illinois Workers' Compensation Act. And Amy, are you going to go into the terms of that a little bit?
Sure. So I have what is an accident? So there are two components to proving that you have a compensable accident under the Illinois Workers' Compensation Act. And we frequently get this question because I think there's a misconception that any injury that occurs while you're at work is a compensable injury, and that's simply not the case. The being at work is the first component. It's the in course of employment component. It is the time, place, and circumstance of the injury. So when you sustain an injury at work, you are in the course of your employment. The second part of the analysis involves whether the injury arose out of your employment. And you need to show that this injury is connected with some risk incidental to your employment so that we can actually say that it was your employment that caused this accidental injury. So when we talk about, are you doing something incidental, to your job duties? What is the risk of your employment that caused this injury? And the courts have categorized this in 3 different ways. There are risks that are distinctly associated with your employment, such as tripping over a defect on the employer's premises, slipping on something spilled at the work site. These are risks that your employer's premises present to you. These are going to be compensable injuries. The second category are risks personal to the employee. So these are your personal pre-existing conditions or infirmities, And these are generally not compensable. However, we have seen some cases where there is an exception if the workplace conditions significantly contribute to the injury or expose the employee to an added or increased risk of injury than would normally have happened just because of the personal infirmity. The third category is neutral risk. These have no particular employment or personal characteristics. These are your random incidents, stray bullets, dog bites, lightning strikes. So injuries resulting from a neutral risk generally do not arise out of employment or are compensable. But there is, again, always exceptions to the rule when you are exposed to the risk to a greater degree than the general public. So when we talk about risk to a greater degree, we're talking about either qualitative or quantitatively, right? So if there's a certain qualitative characteristic, such as, being employed in an area where stray bullets are going to be more common in a dangerous neighborhood, or are we talking about quantitative risk where you have to do something more times than the general public would have to do it? Okay, so I think I might have jumped around out of my order a little bit here, because I think, Brian, I think I put you on the spot in the beginning, and you were supposed to start taking us through McAllister. I apologize about that.
Not a problem. To try to, we're talking little kind of obscure things, but we'd like to take you through one workers' compensation case in particular, all the way through the Supreme Court, and apply the principles that Amy Lee has just outlined. So the case we're going to follow is McAllister versus the Industrial Commission, or North Pond Restaurant. So the facts in our case are: the petitioner is a sous chef for the respondent, North Pond Restaurant. His duties included checking orders, arranging the walk-in cooler, making sauces, and making and prepping food. A coworker mentioned that he had misplaced a can of carrots in the cooler, as they sometimes get knocked underneath the bottom shelves. Mr. McAllister knelt down on both knees to look for the carrots, and when he attempted to get up, he felt a pop in his right knee. So at this point, what do you think? Is what happened to Mr. McAllister an accident? And is there a risk that arose from his employment?
Let's see, we'll wait a second and see if anyone wants to offer their opinion.
Do you think while we're waiting, we can talk about how everyone's probably really distracted by the fact that this guy's name is Kevin McAllister, like Home Alone?
Oh, I did not realize that.
Because I can't stop picturing Macaulay Culkin as the sous chef in the story.
All right, we have one answer, and Jan thinks that it is an accident. I tend to agree, and I think and always thought that there was a risk that arose from the employment. What about you?
So what did the arbitrator say, Brian?
Well, in this case, the arbitrator did find that it was an accident. The arbitrator stated that the claimant's act of looking for the misplaced pan of carrots in the walk-in cooler was an act the employer could have reasonably expected the claimant to perform in order to fulfill his duties as a sous chef. The claimant's knee injury arose out of and in the course of his employment.
But
however, the employer did not like that decision, and as there was their right, they appealed that decision to a panel of 3 commissioners at the Illinois Workers' Compensation Commission. Basically, both sides file a brief, and then they have oral arguments in front of this panel. At the Illinois Workers' Compensation Commission, they reversed the arbitrator's decision in a 2-1 tally. They stated that the claimant failed to prove that his knee injury arose out of his employment because he was subjected to a neutral risk that had no particular employment or personal characteristics. The claimant had not established that he was exposed to this neutral risk to a greater degree than the general public. Basically, that means that they said he could have been standing up anywhere and there was no particular risk to his employment. So in this particular case, the employee was not satisfied with that decision. So they appealed the workers' compensation decision to the Illinois Circuit Court, to the Cook County Circuit Court. Again, the parties submitted briefs and had argument before a circuit court judge. However, they affirmed the decision of the Illinois Workers' Compensation Commission, finding that there was no accident. Again, the employee actually, I'll let Karen talk about the appellate court decision.
All right. The appellate court, we have a special division of the Illinois Appellate Court that just deals with workers' compensation claims. And they heard this case and they affirmed the decision of the circuit court. So they upheld the decision of the Workers' Compensation Commission, finding that there was no accident. All 5 of the justices agreed that the claimant was not injured due to an employment-related risk. The panel did disagree on whether a compensable injury can arise out of the employee's employment if the employee is injured while performing job duties that involve common bodily movements or routine everyday activities. And some of those activities are bending, twisting, reaching, standing up from a kneeling position. There's probably more, but those are the things that the appellate court discussed. The difference of opinion was that 3 justices stated that they believe an injury arises out of the claimant's employment if at the time of the injury, the claimant was performing acts that might be reasonably expected to be performed incidental to his employment or causally connected to what the claimant must do to fulfill his assigned job duties, even if the act involved those everyday activities. In this case, the claimant's knee injury did not arise out of his employment because the risk posed to the claimant from this act of standing up from the kneeling position in the cooler while looking for something that had been misplaced by a coworker was not distinctly related to his employment. 2 separate justices found that it was not an accident and held that a claimant who is injured while performing everyday activities such as standing up from a kneeling position could only obtain compensation under the act if he could establish that his job duties required him to engage in this activity to a greater degree than the general public, even when the activity is directly related to the claimant's job duties. So in this situation, they wanted the claimant to prove that everyone gets up from a kneeling position 2 or 3 times a day, but he does it maybe 10 times a day. Again, what do you think about this? We have some questions. Does this decision uphold the purpose of the Workers' Compensation Act, which is to compensate people who are injured in the course of their employment? And is every physical activity a neutral risk? Does anyone have any opinion out there? All right, we have an answer. One of our attendees has said, no, he does not believe that this decision upholds the purpose of the act. I agree with that. And I do think that if you really read this decision from the appellate court, it is saying that almost everything you do can be done outside of work. So every activity is a neutral risk. Let's see, our attendee just also noted that that's not an activity that people do. So what happened? The court of last resort is the Supreme Court of Illinois. It is very rare for any case to get to the Supreme Court because the Supreme Court chooses the cases that they are going to hear. They decide to hear a workers' compensation claim maybe once every 2 or 3 years. So they only hear cases that have a very important thing that they are trying to decide, a very important issue being decided. So this is one that is a very important issue, and the Supreme Court decided to hear the case. And as you can see, we're happy with the decision. The Supreme Court addressed the issue of, was this an employment-related risk? What they said is that a risk is distinctly associated with an employee's employment if, at the time of the occurrence, the employee was performing acts he was instructed to perform by the employer, acts that he or she had a common law or statutory duty to perform, or acts that the employee might reasonably be expected to perform incident to his or her assigned duties. And it's an or, so any one of those three qualifies. They answered their own question and said, in this case, and said, we find the claimant's knee injury arose out of an employment-related risk because the evidence established that at the time of the occurrence, his injury was caused by one of the risks distinctly associated with his employment as a sous chef. They looked at the evidence and said, and that was the petitioner's testimony at the time of the original hearing, and said the evidence established that the acts that caused his knee injury, kneeling down on the floor in the walk-in cooler to look for the pan of carrots that were misplaced by a coworker, and then standing up from that kneeling position, injuring his knee, were risks incident to his employment because they were acts that his employer might reasonably expect him to perform in fulfilling his assigned duties as a sous chef. You might recall, we'll look at the breakdown of the court's reasoning. The claimant was performing a task his employer could reasonably expect him to perform incident to his job duties. That was, he was in charge of the walk-in cooler, and he actually had a duty as part of his being in charge of the cooler to find misplaced items in the cooler. And the Supreme Court also noted that it is reasonable to expect a coworker to assist another coworker during their employment activities.
Okay, so we have a little bit of a bonus analysis here. And we are basically, looking for any examples or questions anyone in the audience has about maybe something they're wondering would be considered a compensable accident. And we can analyze that and look at whether that injury would arise out of employment. Does anybody have any examples that they're just burning to know would be considered an accident? One of the interesting ones, while you're thinking about it, one of the interesting ones that the Supreme Court cited in the McAllister decision was about this idea about rendering aid to a coworker, is something that arises out of the employer. And there was an interesting one where a claimant was assisting in a removal of a vehicle that was blocking the only entrance to the employer's property, right? So probably not a normal job duty to remove a vehicle or help push a vehicle out of the way, but certainly in furtherance of the employer's business, right? Because this is the only entrance to the property. A vehicle was blocking the door. And so that was found to be incidental to the employment, that sort of rendering aid concept. So Karen, does anyone else have any examples that they want to go through?
Yes, I actually have a very good question here in the chat. It's a really complicated question, but that's okay. We're happy to talk about it. What would happen if you slip on ice on the way into the workplace? And I will start off by answering that is complicated because you have to look at both the arising out of and in the course of. So in the course of part, you have to look at on the way into the workplace. Are you actually on property that is owned or controlled by your employer? Is it a reasonable time before or after the time that you're supposed to be at work? If those are answered yes, then you meet that in the course of. If you happen to, perhaps, let's say you work in the mall and you slip in the parking lot outside of the Ace Hardware where you work, but it's in the big mall and you just park with all the other people, that you probably wouldn't meet the in the course of, because that's not your employer's property. You haven't quite gotten to your workplace yet. With respect to the risk though, yes, generally when someone slips on ice in their employee's parking lot, it is covered. That is considered to be a risk associated with their employment, generally because they look at it as a defect to the employer's property, that the ice or snow or whatever the person slipped on and was injured is considered to be a defect in the fact that the employer controls that property, they're going to be responsible for that slip and fall. I hope that answered that question.
I think so.
All right, does anyone else have any questions? No, it doesn't look like we have any other questions about risk.
I can give
Okay.
I can give you guys a question to see how you would answer, and I could tell you how the court answered. So years ago, I tried a case where the petitioner was a warehouseman loading and unloading inside the employer's premises. A FedEx truck came to drop off a package and was parked outside in a private parking lot. The door, the FedEx driver could not shut the door. It was jammed. So the warehouseman went outside to help assist in closing the door. And in that act, got his hands caught and broke several fingers. So the case was denied because they said he was not doing something to further his own employer's interests, and he volunteered to go out there. But the court held ultimately that, in fact, assisting this other driver was in the interest of his employer and did find it compensable.
I think that's interesting. I think that certainly under this McAllister case, that would make that even a stronger argument.
Correct. I think arbitrators might have split different ways back in the day, but with the new analysis, I think they would hold that to be compensable every time.
Yeah, that's definitely an interesting one, since it's like rendering aid not to a coworker, but to, basically a visitor on the property, right? And I think that definitely is something an employer can reasonably expect its employees to do, right? I mean, you would want your employees to be good people and render aid to whoever comes to the premises, right?
And not to mention that the FedEx driver and that truck were there to further the employer's business purposes.
Exactly.
Correct.
Yeah.
Well, Amy Lee, we have one last question, don't we?
Oh, we do. Here we go. Next slide. So this one was just kind of opening it up to anyone in the audience that, has any lingering questions about what they thought about the decision in McAllister. Is it helpful to workers? Do you think they got it right? Anyone want to have any comments, as we wrap up here about how McAllister turned out?
Well,
I think it's certainly helpful to workers.
Oh, we do have an answer from Casey. He said it's very helpful and the Supreme Court got it right in this case. And I will agree with that.
Okay, so that wraps up our short slideshow. You can always reach out to us with more questions. I have our email addresses up as well as our website. You can also like us on Facebook at Ridge Downs. And we do keep up to date on any changes in the workers' compensation arena and other injury topics. Following us on Facebook is a great way to stay in the loop about those things as they happen in real time. But feel free to always give us a call or shoot us an email with other questions. I'm going to go ahead and end the share.
All right. And if
here.
I can also add to that, to what you just had to say, Amy Lee, please also be aware that we do post these webinars on our YouTube channel where we have many discussions about interesting workers' compensation topics and try and keep you up to date. So please feel free to visit us on our YouTube channel, and you can also share those webinars with your friends and coworkers.
Okay. Anybody else have any other questions about any other workers' comp topics or anything else that we can help you with today? Otherwise, we will wrap up.
Yes, I got in the chat a thank you, very informative. So thank you for attending. We very much appreciate your interest.
All right. All right. Well, with no other lingering burning questions, then I think we'll say goodbye. Thank you, everyone.
Goodbye.
Have a good day.